Not accept the courtroom to be used to justify conmanship. Let it be known. That if people are coming here saying that it's a green and let it be known. Happy. Yes.
Can we see Leshan?
Leshan is here. Watu wanatumiwa hapa kutukona hapa na wanajifanya ati wanafunga matai na masuti hapa. We will not accept. Yes, we will not accept. And I repeat again, we will not accept. We have to talk. When the judge comes in, we'll go quiet. But we have to talk. Judge Akingia, we know. This is our right. This is our courtrooms. That is why we have come here for justice. We have come for justice. Yes. Ladies and gentlemen, don't be intimidated. And I'll tell you, you can talk as much as you want here. Nobody will intimidate you. When the judge comes, we'll respect. They'll do their ruling and we will go. But let nobody intimidate you. And don't be swayed. We have to talk. When the judge comes in, we'll go quiet. But we have to talk. Judge Akingia, we know. This is our right. This is our courtrooms. That is why we have come here for justice. We have come for justice. Yes. Ladies and gentlemen, don't be intimidated. And I'll tell you, you can talk as much as you want here. Nobody will intimidate you. When the judge comes, we'll respect. They'll do their ruling and we will go. But let nobody intimidate you. And don't be swayed. Foile, Kinaleshan, those are people who are here to promote conmanship. And we will not accept that. Who is here? He's an agent of cons. Creator of cons. Anakuja kujifanya hapa anatetea nini? Another represents Mara CIP, Mara KDN advocates, confused people. At least today you've won, you look neat, not those dirty clothes you're normally wearing. Pesa yetu iko na uchungu sana. Mimi pesa yangu ni mshahara yangu nimetekeleza. Sikuomba mtu, sikuiba, na si tender, na si CDF. It is my salary and it will not be stolen. That one no. No way. No way. I will not accept that. Hakuna kitu kama hiyo. Ati watu wanakuja hapa ati wanakuambia restructuring what? How can you accept to be defrauded and you are being told to restructure what? Restructure what? Give us back our money. Sell those damn assets. We get our money back. That is what we want. And again I repeat, don't be intimidated. The courts are here for our justice. And we will speak and be heard. Yes. Yes. Ati watu wanakuja hapa wanashinda hapa kutuzungusha kama wajinga. We are not stupid. We are very learned people. If you look at the list of the people who are law-abiding citizens. Yes. And that is why we have not taken justice against some of these people. It will have been done. But Dande has to go to jail the same way Gakuo is in committee. Gakuya investment is committee. Dande has to go to jail. And the appendages like duty, we will deal with you at the appropriate time. I don't fear. We will deal with you. But don't be used. Here there are so many tears of people. There are people who have died. There are people who are on their hospital beds. There is my friend called Tom Omani. He is sick. He cannot speak. He cannot move. He needed money to pay his hospital bills. He's owed 3 million bob. These guys could not even give him even 1,000 bob. And that is what makes me bitter. It makes me bitter. How can heartless people, somebody is dying. He will not live this year. He will die, I know. And they cannot give him money to pay his medical bills. And they are here, sitting. Represents Mara CIP, Mara KDN advocates, confused people. At least today you've won, you look neat, not those dirty clothes you're normally wearing. Pesa yetu iko na uchungu sana. Mimi pesa yangu ni mshahara yangu nimetekeleza. Sikuomba mtu, sikuiba, na si tender, na si CDF. It is my salary and it will not be stolen. That one no. No way. I will not accept that. Hakuna kitu kama hiyo. Ati watu wanakuja hapa ati wanakuambia restructuring what? How can you accept to be defrauded and you are being told to restructure what? Restructure what? Give us back our money. Sell those damn assets. We get our money back. That is what we want. And again, I repeat, don't be intimidated. The courts are here for our justice. And we will speak and be heard. Yes. Yes. Kuna kitu kingine hapa hivi. Ati watu wanakuja hapa wanashinda hapa kutuzungusha kama wajinga. We are not stupid. We are very learned people. If you look at the list of the people who are
law-abiding citizens.
Yes. And that is why we have not taken justice against some of these people. It will have been done. But Dande has to go to jail the same way Gakuo is in committee. Gakuya investment is committee. Dande has to go to jail. And appendages like duty, we will deal with you at the appropriate time. I don't fear. We will deal with you. But don't be used. Here there are so many tears of people. There are people who have died. There are people who are on their hospital beds. There is my friend called Tom Omani. He is sick. He cannot speak. He cannot move. He needed money to pay his hospital bills. He's owed 3 million bob. These guys could not even give him even 1,000 bob. And that is what makes me bitter. It makes me bitter. How can heartless people, somebody is dying. He will not live this year. He will die, I know. And they cannot give him money to pay his medical bills. And they are here, sitting.
Is in breach of the Insolvency Act, and consequently whether his continuation in office is unlawful. 2. Whether the court should reach Applewood, Miotoni, Taraji, Saisuts, Riverrun, Athi River, the Alma and Newton. 3. Whether the official receiver should be allowed to enforce the preservation orders issued. Then whether a meeting should be convened to table and deliberate on the debt settlement proposal by CHYS, whether a caveat should be registered against the Athi River properties, whether the liquidation orders issued should apply to the homeowners/investors who already had good titles at the time the liquidation orders were issued. I also deal with the issue of whether vesting orders should be issued in respect of Mystic Plains, Taraji, Ridge, and Applewood properties, and also whether Edwin, Harold, Diane, Dande should be enjoined as an interested party in these proceedings. On the first issue, whether the liquidator is in breach of the Insolvency Act and consequently whether his continuation in office is unlawful, the applicants who raised this issue accuse the official receiver of contravening Section 438 of the Insolvency Act by, amongst others, failing to call for a creditors' meeting within 3 months for purposes of appointing a person to replace him as a liquidator. Can seek to be allowed to hold a creditors' meeting for purposes of removing the liquidator, citing Section 468 of the Insolvency Act. The official receiver refutes the allegations presented by these creditors and argues that the office has exercised its duties diligently on behalf of the creditors and in accordance with the Insolvency Act. It is the official receiver's submission that the applicants can seek to be allowed to hold a creditors' meeting for purposes of removing the liquidator, citing Section 468 of the Insolvency Act. The official receiver refutes the allegations presented by these creditors and argues that the office has exercised its duties diligently on behalf of the creditors and in accordance with the Insolvency Act. It is the official receiver's submission that the applicants have missed the Act, as this provision envisions a scenario where the court makes a liquidation order but fails to appoint a liquidator. For context, I have laid out what Section 438 of the Insolvency Act provides, which I see no need to regurgitate. From my reading of Sections 438, 2 and 3 of the Insolvency Act, I am inclined to agree with the submission that under Section 438, the official receiver automatically assumes the role of a de facto liquidator when no other liquidator has been appointed. In this capacity, the official receiver acts as the liquidator until another individual is appointed to the position. In such a scenario, Section 438 requires the official receiver to convene a meeting of creditors within 3 months for the purpose of appointing a substantive liquidator. However, it is important to note that this provision does not apply when the official receiver has been appointed as the substantive liquidator by the court. In the present, this court explicitly stated, and I quote, "I hereby appoint the official receiver as the liquidator of the company." This appointment by the court was not made under Section 437 of the Insolvency Act, which governs the appointment of provisional liquidator. This distinction reinforces the position that the official receiver was appointed as the substantive liquidator of CHYS. Consequently, the official receiver was not obliged to convene a creditors' meeting to appoint another liquidator as mandated by Section 438 of the Insolvency Act. I note that the official receiver has provided evidence demonstrating compliance with the statutory requirements required of that role as liquidator was published in the Kenya Gazette, that a notice of the first creditors meeting held on the 7th of March 2023 was issued, and that the official receiver has regularly updated the creditors on the progress of the liquidation process. Regarding the admission of proof of debts from creditors, my view is that the Act envisions this as a continuous process. This reasoning accounts for the varying types of creditors, the nature of their claims, and the different stages at which such claims may arise or be finalized during the insolvency proceedings. The fact that not all the creditors have had their proof of debts responded to or admitted does not in itself therefore justify the removal of the liquidator from office. In light of these observations, I find no merit in the contention that the official receiver has contravened the Insolvency Act. Furthermore, having established that the official receiver was substantively appointed by the court as liquidator, I find that the official receiver is lawfully serving in that capacity, and consequently the prayers sought are without merit and they are for dismissal. On the second, court should lift the preservation orders issued in the ruling of 6th January 2023 in respect of the properties that I have stated already. In the ruling of 6th January, this court held that it was prudent to preserve the aforementioned properties until the assets of CHYS are realized by the official receiver. The court further directed that the affected entities, namely the SPVs, would be afforded an opportunity to present their cases. On this basis, the applicants, being the special purpose vehicles who have since been enjoined as interested parties in this matter, now seek the lifting of the preservation orders. In their separate applications, they contend that they were not parties to the initial proceedings and were not heard before the preservation orders were issued. The SPVs further argue that they are separate and distinct from their partners and managers, and that they are entitled to own property in their own names. They contend that lumping together the SPVs with the liquidated entities into one entity and holding the SPVs liable for contracts to which they are not privy violates the doctrine of corporate personality and privity of contract. That the financing agreements between the SPVs and the liquidated entity were above board and that they do not suffice to demonstrate a clear chain of tracing. As such, the official receiver cannot depend on the doctrine of tracing if that chain is not established. In response, the creditors opposed to the applications. In its application for administration, CHYS did acknowledge that it lent out money to the SPVs. The court, in its ruling of 17th January, found that the money lent out belonged to the creditors of CHYS and that it was invested in the various preserved properties. They contend that this issue of lifting the preservation orders has been overtaken by events as the court in the said ruling vested the preserved properties in the official receiver. The creditors aver that lifting the preservation orders would expose them and that they would not be able to realize their investments. I have referred to a decision, Middle East Bank Kenya Limited versus Widad Hussein, Badru and Hassan, Salem and Swab, in which the court cited with approval from a Canadian decision which extensively discusses the doctrine of tracing. I need not go through that quotation. However, in line with the reasoning above, in the rulings of 6th January 2023 and 17th January 2024, the court reiterated that the doctrine of tracing was properly invoked and demonstrated, and that there is a chain linking the creditor's money and the preserved properties acquired by the SPVs. In their current applications, the special purpose vehicles have not presented any new arguments or evidence beyond those already raised in the prior proceedings. These arguments were carefully considered and formed the basis of the court's rulings. It remains the case that while the SPVs are indeed separate legal entities from CHYS, they are undeniably connected through shared control and directorship under Edwin Dande, CHYS's chief executive. Additionally, it has been established that the funds utilized by the SPVs can be traced directly to the deposits made by CHYS's creditors. The SPVs have yet to demonstrate that the subject properties are independent of the funds received from CHYS's creditors. Furthermore, CHYS's influence over the SPVs, as I have said, exercised through its CEO, Edwin Dande, remains unbroken. Significant concerns persist contract to shield themselves from scrutiny. They must move beyond those protective legal constructs and provide transparent answers to the creditors' questions. Such accountability cannot be achieved if the preserved properties remain under the control of CHYS, the SPVs, or their managers. It is therefore my finding that lifting or varying the preservation orders, as well as exempting the properties in question from the liquidation process, which is intended to benefit the creditors as a whole, would significantly undermine the realization efforts being carried out by the official receiver. Such actions would further exacerbate an already precarious situation, potentially leaving creditors unable to recover their investments. And for these reasons, I find that the SPVs have failed to provide any valid or justifiable grounds for the court to lift, vary, or set aside the preservation orders issued on 6th January 2023, and accordingly the prayers sought by the SPVs in their applications are without merit and are also for dismissal. Preservation orders are the applications brought by interested parties whose claim is that they are bona fide purchasers and investors in some under the various SPVs. These parties argue that the said properties should be excluded from the liquidation process as they have valid and enforceable legal interests in the properties. They further contend that including the properties in the liquidation process would unjustly deprive them of their investments and would amount to an infringement of their property rights. On this basis, they seek orders to lift the preservation orders and exclude their respective properties in question from liquidation, maintaining that their interests are distinct from and unrelated to the funds of CHYS's creditors. The central issue for determination is whether the claims of the interested parties who assert legal ownership or investment interests in these properties supersede the rights of the creditors to recover their funds under the liquidation process. It is a well-established principle of insolvency law that only the assets that belong to an liquidated entity can be subject to administration and distribution amongst its creditors. Section 3.1 of the Insolvency Act expressly identifies one of the primary objectives of insolvency proceedings as the establishment of a framework for the efficient and equitable administration, bold underline, of the assets of insolvent companies and other corporate bodies. In this regard, Section 448(1)(b) of the Insolvency Act imposes a duty on the liquidator to collect, preserve, and apply, again emphasis, the assets of the insolvent company. This process involves verifying ownership, tracing funds, and challenging claims to assets that are improperly or fraudulently withheld. By implication, assets not proven to belong to the liquidated company fall outside the liquidator's jurisdiction and cannot be included in the distribution process. This framework reflects the dual purpose of insolvency law, which is to maximize the recovery for creditors, while at the same time respecting the legal rights of third parties. It follows, therefore, that assets that have been purchased by bona fide purchasers for value without notice of the company's insolvency or impending liquidation do not form part of CHYS or other such liquidated companies' assets. The onus is on the applicants to demonstrate ownership and good title to such assets and provide sufficient evidence to the liquidator to justify their exemption from the liquidation estate. This requires the applicants to establish that their transactions were conducted in good faith for valuable consideration and, I emphasize, without knowledge of the company's financial distress. It must be emphasized that the liquidator retains the authority under insolvency law to challenge or avoid transactions where assets are transferred with the knowledge of and in anticipation of the company's insolvency or liquidation. Such transfers are considered attempts to defraud creditors and can be avoided so as to preserve the integrity of the liquidation process. Section 498 of the Insolvency Act, as such, the liquidator is empowered to scrutinize all transactions involving company assets, particularly those occurring in the period leading up to the insolvency, to determine whether such transfers are legitimate or they are designed to frustrate the rights of creditors. These applications are therefore subject to the scrutiny of the official receiver as liquidator. I turn now to the issue as to when and deliberate on the debt settlement proposal forwarded by CHYS. And I note that this court, in its directions of 27 September 2024, directed the official receiver to call for a meeting of the creditors. I think the only issue for the court's determination arising out of this issue is whether the debt settlement proposal should be tabled and deliberated by the creditors in that meeting. The applicants state that they are creditors of CHYS and are members of the Creditors Restructuring Committee, CRC, consisting of 7 members, duly elected by over 600 creditors of CHYS and CPN. According to them, they feel that they would not be able to recoup their investments as unsecured creditors through the liquidation route and would have a better chance to recoup their entire principal through restructuring of the debt owed. The said creditors contend that their cumulative debt amounts to $4,849,390,798 and 25 cents. It is their wish to adopt the debt settlement proposal through restructuring of the debt owed to them by CHYS, CPN, and they have signed support letters to that extent. The official receiver, in opposing the application, contends that the DSP is a creation of cytonn, presented to the administrator of CHYS during the administration phase. Following a review, the administrator concluded that the proposal was not viable and determined that CHYS could not be salvaged as a going concern. This assessment formed the basis for the subsequent decision to place CHYS into liquidation. First, that the proposal is unsupported by adequate documentation. It relies on assumptions and misrepresentations that lack a factual basis. Second, critical questions regarding its feasibility and practical implementation remain unanswered, making it premature to subject the proposal to a vote. The official receiver emphasizes that given these deficiencies, it would be impractical and inappropriate to adopt or implement the proposal in its current form. These factors reinforce the conclusion that the proposal is untenable and cannot advance the liquidation process. Having carefully reviewed the debt settlement proposal, I am inclined to agree with the submission that it is devoid of supporting documentation and substantive detail. It amounts to little more than a colorful presentation of hope rather than a practical and actionable plan. The proposal is purportedly designed to achieve 100% recovery of the principal debt through the sale of CHYS's assets. Ironically, the very course of action that the official receiver is already undertaking. Yet the applicants oppose the official receiver's efforts and instead propose to take over the sale and distribution of the assets themselves. This, in my view, is a clear encroachment on the statutory responsibilities vested in the official receiver as liquidator, responsibilities that cannot be lawfully assumed by any other party. I further concur with the submission that the proposal is built on speculative assumptions, particularly regarding the appreciation of the subject property's value over time and the eventual recovery of creditors' funds upon their sale. The plan also references the procurement of an investor who could purportedly buy out most of the creditors' investments, but provides no specifics about who these potential investors might be or the feasibility of securing such an investment. As was emphasized in Retasker Mattresses Limited, restructuring plans must include sufficient detail. The applicant's proposal falls far short of these requirements, rendering it impractical and incapable of providing a clear path forward. In essence, the proposed settlement plan merely reiterates what the court and the creditors already know, that CHYS is in severe financial distress. While it optimistically suggests that there is still a chance to rescue CHYS as a going concern, this claim is contradicted by the findings of both the administrator and the official receiver, who have concluded that a rescue is not feasible. It is noted that prior to the issuance of the liquidation order, CHYS was placed under administration. The purpose of administration is to explore the possibility of rescuing a company as a going concern or stabilizing its operations to achieve a better outcome for creditors than immediate issued a liquidation order. Given this context, the proposal now being advanced by the applicants is not open to re-litigation. The matter was fully canvassed during the administration process, and the court's decision to place CHYS under liquidation renders any further discussion of this proposal moot. Allowing the same proposal to be reconsidered would not only undermine the finality of the court's previous determination, but will also delay the ongoing liquidation process to the detriment of creditors. The proper course of action now lies in adhering to the liquidation framework already in place rather than revisiting the proposals that have been conclusively rejected. In any case, I further note that the proposal is presented by a faction of creditors identifying themselves as Creditors Restructuring Committee. This raises an additional issue as the Insolvency Act, in my view, does not envisage the existence of parallel processes or separate creditors' meetings other than those convened under the auspices of the liquidator. The applicants or any other parties purporting to act in this capacity lack the legal authority to organize or present proposals outside of the framework provided by the Act. The rationale behind this restriction is, in my view, grounded in the principle of equality amongst creditors under insolvency law. Allowing the CRC or any self-appointed group of creditors to act independently of the liquidator risks undermining the orderly and impartial administration of the insolvency process. Such parallel initiatives could fragment creditor representation, delay the liquidation process, and jeopardize the efficient realization. We emphasized that the Office of the Liquidator is the sole authority empowered by law to oversee the administration of the insolvent company's assets, convene creditors' meetings, and evaluate restructuring proposals, if at all. Any efforts to sidestep this statutory framework by splinter groups, however well-intentioned, lack legal foundation and threaten to derail the liquidation process. Creditors must present their concerns or proposals within the structure established by the Act so as to ensure transparency, accountability, and fairness to all stakeholders. Against the Athi River properties, and having determined that the preservation orders against the other subject properties should not be lifted for purposes of the liquidation process, I further find that no caveat can be registered against the Athi River properties as sought by CIP 4 LLP. Allowing the registration of such a caveat would defeat the purpose and objectives of the liquidation process by restricting the liquidator's ability to manage and realize the assets of CHYS for the benefit of the creditors. Additionally, it would contradict the preservation orders already in place, which are designed to safeguard the subject properties from interference and ensure that they remain available for equitable distribution amongst the creditors. On the issue as to whether vesting orders should be issued in respect of the properties again that have been referred to, the official receiver notes that this court issued preservation orders in respect of the above properties and now prays for vesting orders in respect of the same. The authority to assume control of all the property to which a company is or appears to be entitled. Section 445 of the Act in turn provides for vesting orders which have the effect of transferring the legal ownership of a liquidated entity's assets to the liquidator. I have already reiterated this court's finding regarding the financial relationship and dealings between CHYS in liquidation to the independent SPVs, which were registered by CIM. Similarly, having determined that the preservation orders in respect of the subject properties should remain in force, the logical and necessary consequence is for the properties to vest in the official receiver as liquidator. This will enable the liquidator, as I have stated already, to effectively realize the properties and apply the proceeds for the benefit of the creditors in accordance with the objectives of the liquidation process. The other issue is whether Edwin Harold Diane Dunde should be enjoined as an interested party in these proceedings Mr. Dande has sought to be enjoined in these proceedings on the basis that he has also personally invested in the SPVs. Given these roles, he asserts that he has a direct and substantial interest in the outcome of these proceedings. While the official receiver and some creditors have opposed Mr. Dande's application to be enjoined, I note that he has already technically been enjoined in these proceedings by virtue of other applications where he, along with others, sought similar relief. Furthermore, it is undisputed that Mr. Dande has actively participated in the proceedings, including swearing affidavits on behalf of CHYS and attending meetings with the official receiver. Both the official receiver and the creditors acknowledge his involvement, which suggests that his inclusion as an interested party would formalize a role he is already performing. I do find that Mr. Dande has a legitimate stake and interest in these proceedings by virtue of his position as a director and majority shareholder of CIMP, his role in promoting CHYS and CPN, and his personal investments in the SPVs. And joining him as an interested party will not cause any prejudice to the official receiver or the creditors, and is consistent with ensuring that all parties with a significant interest are included in the process. However, as I have already found that the debt settlement plan has been overtaken by events and deemed it unviable, Mr. Dande's prayer to explain or advocate for the same cannot be granted. The liquidation process has moved beyond the point of considering such proposals, and the focus must now remain on the orderly realization of assets and distribution to creditors under the framework of the Insolvency Act. While Mr. Dande may party, his involvement must align with the objectives of the liquidation and cannot be used to reopen or relitigate settled matters. And in conclusion, I make the following dispositive. Number one, the applications dated 15th April 2024, 9th April 2024, 11th March 2024, 20th December 2023, 20th November 2023, 1st November 2023, 17th November 2023, 3rd July 2023, 16th November 2023, and 18th August 2023 are dismissed. 2. The application dated 2nd October 2024 is allowed, but only to the extent that Edwin Harold Diane Dande is enjoined as an interested party in these proceedings. Number 3, the applications dated 4th October 2024 are allowed, and the official receiver is allowed to enforce the preservation orders issued on the 6th January 2023 over the properties listed in the application, otherwise known as Riverrun, Tarangi, The Ridge, 12.5% shares in Superior Homes Kenya Limited, Applewood, Sisuits, Alma, Mystic Plain / Newton, to the extent of Cytonn Investment Partners 4, as per the sale agreement. I believe that should be interest, to the extent of that interest, per the sale agreement dated 18th December 2015. 4. The Officer Commanding Station, OCS, for the areas where the respective properties above are situated, as specifically listed in the application, is hereby directed, or rather are hereby directed, to assist the official receiver enforce these orders. 5. The properties commonly known as, again, The Ridge, Taraji, Miotoni, Applewoods, and Mystic Plain / Newton shall vest with the official receiver for purposes of valuation and realization. The official receiver shall apply and be issued with provisional titles in respect of these properties in the event that Cytonn Investments or Edwin Dande or any other Cytonn entity fails to surrender the same within 7 days of these orders. And 6, the matter shall be mentioned to confirm compliance and issuance of further directions. And finally, leave to appeal against this ruling is hereby granted to any party desirous of such an appeal, and in this regard, certified copies and copies of this composite ruling shall be availed to any party upon payment of the requisite fees. The court file and on CTS by Monday,